The first letter showed up on a Tuesday morning, folded inside one of those stiff yellow envelopes people use when they want you to feel nervous before you even open it. It said I had 14 days to correct multiple violations on my property, or the Homeowners Association would begin enforcement proceedings. $450 in fines, possible liens after that. Real official-sounding stuff. The funny part was, the people who sent it had absolutely no idea the building they worked in was sitting on land that belonged to me. And not just the building, either. Their office, their parking lot, the road leading into the subdivision, every bit of it sat on acreage my family had owned since Calvin Coolidge was president. They just didn't know it yet. See, my name's Wade Mercer, and up until that week I hadn't thought much about Blackwater Cove Estates or the people running it. They were just another lakeside development built too close to old ranch land, full of expensive boats and folks who liked posting patriotic quotes online while paying somebody else to mow their grass. I mostly kept to myself out at Mercer Hollow, same way my father did, same way my grandfather Eli did before him. 130 acres wrapped around the north side of Belmere Lake, old cedar fencing, cattle pasture, a machine shed from the 50s that leaned a little farther every winter but somehow never fell over. The kind of place where mornings started with coffee so strong it could dissolve a spoon and ended with frogs chirping under the dock. That morning I was repairing fence posts near the eastern bank, just tapping nails back into old cedar rails while the fog still hung low over the water. Couple mallards floated past like they had nowhere important to be. Then I heard tires crunching gravel. White SUV. Spotless. The kind of vehicle that looked uncomfortable on dirt. Two people climbed out wearing business clothes that made no sense for the amount of mud around them. The taller guy introduced himself as Trevor Dane from Blackwater Cove Community Association, said it with that rehearsed smile people learn in management seminars. Woman beside him carried a clipboard and avoided eye contact like she already knew this conversation was stupid. Trevor handed me the envelope and started talking about aesthetic standards, unauthorized fencing modifications, landscape neglect. I remember staring at his loafers sinking into wet grass while he explained to me that my property was visually inconsistent with the surrounding community image. I almost laughed right there. Instead, I just listened. My granddad used to say the fastest way to learn what somebody's really after is to let them keep talking after they should have stopped. So I let him go. He mentioned escalating penalties, possible corrective action, community jurisdiction. He said all of it like he practiced in front of a bathroom mirror. Then they got back in the SUV and left, probably expecting me to start panicking the second they disappeared down the drive. I opened the letter at the kitchen table maybe 20 minutes later. It was one page of legal-sounding language written by somebody who desperately wanted to sound smarter than they were. Fence violation, grass violation, structure compliance violation. Apparently my barn was now considered an unapproved visual obstruction, which was impressive considering that barn had been standing there since Harry Truman was in office. But down near the bottom, there was a sentence that made me stop rereading and sit back in my chair. Failure to comply may result in enforcement action regarding adjacent and affiliated properties. Affiliated properties. That wording bothered me. Not because it scared me, because it told me these people either didn't understand where their authority ended or they were hoping I didn't. And those are two very different kinds of dangerous. I got up, walked to the back room, and pulled open the second drawer of an old filing cabinet my father bought sometime in the 70s. Every property document my family ever kept was inside there, organized by year in faded folders. My ex-wife used to joke that if the house ever caught fire, I'd probably save those papers before I saved the furniture. Truth is, where I come from, paperwork is survival. Land gets stolen with signatures more often than guns. I found the folder I wanted almost immediately. Green tab, lease agreement, 1987. I carried it back to the kitchen and laid it beside the HOA letter. The lease was old enough to smell like dust and attic wood. Signed by my grandfather Eli Mercer and a developer named Randall Pike, the man who originally built Blackwater Cove before dying broke in Arizona sometime around 2004. Most of the lease covered ordinary stuff: utility access, maintenance rights, shoreline restrictions. But Section 7 was the reason my grandfather had paid a lawyer good money all those years ago. Any transfer or reassignment of lease rights required written acknowledgement by the Mercer family, or the agreement would be considered procedurally defective. My grandfather had underlined that clause himself in blue ink. I remember sitting there at the kitchen table staring at that sentence while rain started tapping softly against the windows. Because suddenly the whole thing felt different. This wasn't some bored HOA arguing about grass height. This felt like people testing fences they didn't realize were electric. And the strangest part was, I still don't think they understood what they were standing on. I picked up my phone and scrolled to a number I hadn't called in almost a year. Nolan Pierce, land use attorney. Meanest calm person I've ever met in my life. The kind of man who could destroy somebody's legal argument while sounding like he was ordering breakfast. My thumb hovered over the call button for a second. Then I looked back at the letter one more time and said out loud to an empty kitchen, "Well, this ought to get interesting." Nolan didn't laugh when I explained the situation, which honestly made me more nervous than if he had. Most lawyers laugh when they think somebody's exaggerating. Nolan just listened, quiet the whole time except for the occasional little hum in his throat while I walked him through the lease agreement, the HOA letters, and the part about affiliated properties. Finally, he said, "Wade, do me a favor and don't respond to them yet." I leaned back in my chair and looked out the kitchen window toward the lake. Wasn't planning to. "Good," he said. "People who rush first usually don't have the documents." That sounded exactly like something my grandfather would have said, which immediately made me trust him more. So for the next few days, I slowed down. That's the thing most folks don't understand about land disputes. Movies make you think the winning move is some dramatic confrontation, somebody pounding a desk or threatening lawsuits in a parking lot. Real life's usually quieter than that. The dangerous people are the ones who go home, make coffee, and start pulling records. Nolan had me request every filing tied to the 18-acre commercial parcel leased to Blackwater Cove Estates. Assignments, easements, tax filings, amendments, everything from 1987 forward. While the county processed the request, I reread the original lease line by line at my kitchen table with a yellow legal pad beside me. By the second night, I'd already circled for clauses that made me uncomfortable in a very good way. Then the county records came in. 32 pages scanned into a PDF. I printed every one of them and spread them across my dining room table like poker cards. Most of it was routine paperwork, until I found the assignment transfer from 2002. That was the moment things shifted. See, Randall Pike's original development company had eventually transferred operational control of Blackwater Cove to the Homeowners Association after the subdivision filled up. Totally normal process. Except there was one problem. The transfer document had signatures from Pike Development and the HOA board. It had notarization. It had county recording stamps. What it did not have was a single signature from anyone named Mercer. No acknowledgement. No consent. Nothing. They had transferred occupancy rights on leased Mercer land without satisfying the one clause my grandfather had specifically written to prevent exactly that. I remember just sitting there staring at the page while the refrigerator hummed behind me. It's hard to explain the feeling. It wasn't excitement exactly. More like realizing halfway through a football game that the other team's been running the wrong playbook the entire time. I called Nolan immediately. He was quiet for maybe 10 seconds after I explained what I'd found. Then he said, "Bring every document you have to my office Thursday morning." Nolan Pierce's office sat on the 4th floor of an old brick building downtown above a tax accountant and a barber shop that still charged $12 for haircuts. When I walked in carrying 2 banker boxes full of records, Nolan looked over his glasses and said, "You know, most clients show up with screenshots and panic attacks." "I'm old-fashioned," I told him. He spent nearly an hour reviewing the files while I sat in the lobby drinking burnt coffee from a paper cup. Every once in a while I'd hear pages turning faster. Then silence. Then more pages. Finally his assistant poked her head out and said, "Mr. Pierce wants you back in the conference room." Nolan was standing beside a county parcel map when I walked in. He tapped the shaded rectangle representing the leased acreage. "Everything the HOA actually operates," he said slowly. "Their office, community hall, maintenance garage, parking lot. All of it sits inside this parcel." "I know." He looked at me for a second. "And the assignment they rely on to occupy that parcel appears procedurally defective." There it was. Said out loud. "Real now." Nolan removed his glasses and rubbed the bridge of his nose. "Wade, I need you to understand something. If a judge agrees this assignment never satisfied the lease conditions, Blackwater Cove could suddenly have a very complicated relationship with the land underneath its own buildings. Complicated, I repeated. That's lawyer talk for catastrophic, isn't it? He smiled a little at that. Sometimes. Then he laid out the next steps. First, formal notice to the HOA regarding the defective assignment. Second, challenge every fine based on lack of jurisdiction. Third, and this part mattered more than I realized at the time, document absolutely everything they did after receiving notice. Because people who think they're untouchable, Nolan said, usually make mistakes when they panic. Turns out he was right. The second letter arrived 11 days later. Certified mail this time. $1,200 in fines now. They'd expanded the violations too. My grandfather's machine shed was suddenly considered an unlawful structure. My fence violated visual continuity standards. And apparently my driveway needed HOA-approved signage. My driveway, half a mile from their nearest boundary marker. I read the whole thing twice, then set it down and laughed so hard I scared my dog under the table. Because at that point it wasn't subtle anymore. They weren't enforcing standards. They were expanding territory. Like kids stretching a blanket over furniture, trying to see how much space they could claim before somebody noticed. That same afternoon, my neighbor Elaine Foster stopped by. Elaine lived inside Blackwater Cove and knew everybody's business without ever sounding like a gossip. She brought peach preserves and information in equal amounts. We sat on the porch drinking iced tea while she casually mentioned the HOA board had been discussing western expansion opportunities during recent meetings. Storage units maybe, she said. Additional parking. New gated entrance. I looked toward the western pasture while she talked. 40 acres of open Mercer land sat directly adjacent to the HOA property. Land I had never offered for sale, never leased, never discussed with anybody. Suddenly the fines made perfect sense. They weren't trying to punish me. They were building a record. If they could establish enough community noncompliance issues, they'd eventually argue my land negatively impacted surrounding property values and push for acquisition leverage. It was ambitious. Slimy, but ambitious. Who's pushing it? I asked. Elaine snorted softly. Vivian Caro. There it was. Vivian Caro was president of the HOA board, former real estate broker, one of those polished women who treated every conversation like she was already winning it. I'd met her twice over the years. Both times she spoke to me like I was a stubborn inconvenience standing in the way of a nicer brochure. Elaine lowered her voice. Wade, I think she honestly believes that ranch should belong to the community eventually. That's so. She keeps calling it underutilized lakeside property. I looked out toward the water and shook my head. Funny thing about people with money. Eventually they start believing untouched land is somehow wasted if nobody's monetizing it. A week later, I attended my first Blackwater Cove HOA meeting. Wasn't invited. Didn't need to be. They held it in the community hall sitting right there on leased Mercer land, though nobody in that room seemed aware of the irony. I took a seat in the back row beside an old man asleep in a fishing hat and just listened. Vivian Caro stood at the front beside a projector screen wearing a cream-colored blazer that probably cost more than my truck payment. About 20 minutes into the meeting, she clicked to an aerial photograph of my ranch taken by drone. Clear as day. Fence lines. Barn. Eastern pasture. My dock. As you can see, Vivian said smoothly, the condition of the adjacent property continues to create aesthetic concerns for residents and prospective buyers. Then their attorney, Stuart Bell, stood up and started quoting state HOA statutes about adjacent community standards and enforcement authority. I wrote down the statute number immediately because Nolan had already warned me this might happen. Sure enough, Bell quoted the first half of the law perfectly and conveniently ignored the second half, stating the statute applied only to properties already bound by recorded HOA covenants. My ranch wasn't. Never had been. He knew that too. That's what irritated me most. Not arrogance, calculation. Then Vivian spotted me in the back row. Her smile tightened for maybe half a second. Mr. Mercer, she said sweetly, would you like to address the board this evening? Whole room turned to look at me. I closed my notebook slowly. No, ma'am, I said. Just listening. You could feel the irritation ripple across her face for one tiny second before the smile came back. Because that's the thing about people who rely on control. Silence makes them nervous, especially when they can't read it. After the meeting, I walked outside into the parking lot and just stood there for a minute looking at the community hall. Lights glowing through the windows. Expensive SUVs lined up in neat rows. all sitting on land my grandfather leased with a clause nobody bothered to honor. I wasn't angry standing there. Honestly, I felt something colder than anger. The kind of calm you get right before a storm finally breaks, and everybody still outside thinks the weather's fine. That night, Nolan emailed the formal notice regarding the defective assignment directly to the HOA board and their attorney. 2 days later, everything started falling apart. The first sign they were rattled came from Elaine. She called me Thursday morning whispering from her car, like she was reporting organized crime activity instead of HOA drama. Vivian lost it during the board meeting, she said. Stuart Bell told them the lease issue was probably just intimidation tactics, but nobody looked convinced. Probably, I asked. Elaine laughed nervously. That word didn't help. Apparently Vivian insisted they move forward aggressively before I gained momentum, which is exactly the kind of phrase people use right before driving straight into a wall. By Friday morning, they'd posted a statement on the community forum accusing me of refusing to cooperate with reasonable property standards and damaging neighborhood values through neglect. They didn't use my name until the third paragraph, which I'm sure their lawyer thought was very clever. Problem was, they still used it. Nolan told me to screenshot everything immediately. People always think deleting posts later erases intent, he said. It doesn't. Then came the landscaping crew. White pickup truck, trailer full of equipment, 2 confused-looking guys in reflective vests pulling into my driveway around 9 in the morning. I walked outside before they even killed the engine. The crew foreman held up a clipboard and said, "We're here for corrective maintenance under HOA authorization. You're about half a mile outside your authority," I told him. He looked uncomfortable immediately, which told me he'd probably been fed a very incomplete version of reality. I asked if I could see the work order. HOA letterhead right at the top. Property Compliance Correction. Authorized access approved by Blackwater Cove Community Association. I pointed one of my security cameras toward the paper and said, "Sir, I need you to understand something before you take one more step. You are currently standing on private Mercer property without owner consent, and I am documenting this entire interaction." The poor guy looked like he wanted to teleport home. He made a phone call standing beside the truck while his workers pretended not to hear any of it. 12 minutes later, they backed out of my driveway and left. Nolan nearly smiled when I sent him the footage. "Trespass attempt authorized in writing," he said. "That's unusually helpful of them." But the real mistake came 3 days later when the HOA officially filed suit against me in county court seeking enforcement authority over my property. Nolan called me the second he received the paperwork. "Wade," he said calmly. "They just opened discovery." Meaning now we get to put every single thing they've done in front of a judge. The counterclaim Nolan filed was 46 pages long and read less like a defense and more like somebody slowly assembling a guillotine. Defamation from the community posts. Unauthorized entry attempt. Drone surveillance violations. Abuse of process. Jurisdictional fraud. And at the center of everything, the defective land assignment supporting the entire HOA property footprint. 2 days after filing, Stuart Bell called Nolan requesting settlement discussions. That alone told us plenty. Confident lawyers don't suddenly ask for private conversations after acting invincible for weeks. But Nolan declined anything informal. "We'll discuss settlement after the hearing date," he told him. In the meantime, we proceed. The hearing happened on a humid Monday morning in July. Small county courtroom, pale wooden walls, old air conditioning rattling like it was fighting for its life. Elaine sat behind me in the gallery beside 3 Blackwater Cove residents pretending not to stare at Vivian Caro across the aisle. Vivian looked immaculate as always, though there was something tighter around her eyes now. Stuart Bell looked worse. He had the expression of a man who hadn't slept properly in days. Judge Rebecca Holloway entered exactly at 9 o'clock, carrying a stack of filings thick enough to hurt somebody with. She wasted almost no time on introductions. "Before we address aesthetic enforcement claims," she said, looking directly at Stuart Bell, "I would first like clarification regarding jurisdiction over Mr. Mercer's property." That sentence changed the temperature of the room instantly. Bell stood and launched into a polished argument about community standards, adjacent property impacts, statutory interpretation. Real smooth presentation. Would have sounded convincing too if Nolan hadn't already dismantled half of it in writing. Judge Holloway listened without interrupting, which honestly seemed to make Bell more confident. Then she turned toward our table. Mr. Pierce. Nolan stood slowly, buttoned his jacket, and carried exactly 3 documents to the podium. The original 1987 lease, the 2002 assignment transfer, and the county parcel map. That was it. No theatrics, no dramatic pacing, just paperwork. Your Honor, he began. The petitioner is requesting enforcement authority over land never subjected to any recorded HOA covenant. Furthermore, the administrative property from which the petitioner operates appears occupied under a lease assignment that did not satisfy mandatory transfer conditions required by the original agreement. Then he placed the parcel map onto the courtroom projector. Red boundary lines lit up the screen. Community hall, parking lot, HOA office, maintenance building. Every inch of it highlighted neatly inside Mercer-owned acreage. You could actually hear somebody in the gallery whisper, "Holy hell," under their breath. Judge Holloway leaned forward studying the map for several long seconds before looking directly at Vivian Caro. "Ms. Caro," she asked calmly, "were you aware the association's facilities are situated on property owned by Mr. Mercer?" Vivian looked towards Stuart Bell immediately. Bell stared at his legal pad like maybe a better answer might magically appear on it. Finally, Vivian cleared her throat. "We relied upon the validity of the 2002 assignment agreement." Without independently reviewing the original lease conditions, the judge asked. Silence. Long enough silence to become an answer all by itself. Judge Holloway nodded once slowly. "I see." That was the moment I knew it was over. Not because she sounded angry. Judges rarely do. It was the disappointment in her voice. Like a teacher realizing the student didn't just get the wrong answer, they skipped the chapter entirely. Her ruling came from the bench less than 40 minutes later. Every fine issued against Mercer Hollow Ranch dismissed for lack of jurisdictional authority. Immediate injunction against further HOA enforcement actions pending review of the assignment dispute. Formal judicial review scheduled regarding enforceability of the 2002 transfer agreement. Vivian looked physically smaller somehow sitting there hearing it. Stuart Bell didn't even try talking to reporters outside afterward. Nolan did, briefly. Property rights, he told them, still require legal foundations no matter how organized an institution appears to be. Clean, simple, deadly. The settlement negotiations lasted almost 6 weeks after that hearing. By the end of it, Blackwater Cove agreed to pay my legal fees, damages related to the drone surveillance and trespass attempt, and issue a public apology on the same community forum where they'd accused me of damaging property values. But the biggest change involved the lease itself. The judge ultimately ruled the original assignment had indeed been procedurally defective, meaning the HOA needed an entirely new agreement if they wanted to continue occupying the property. This time the terms came from me. Increased commercial lease rates. Strict limitations on future expansion. Annual disclosure requirements to all HOA residents clarifying the land ownership arrangement. And an 18-month termination protection clause replacing the old 90-day provision. Vivian Caro resigned before the revised agreement was finalized. Officially, it was for personal reasons. Unofficially, 4 board members had already demanded a leadership review after realizing just how close the community came to losing operational control of its own facilities. Funny thing is, even after all that, some residents still blamed me. That part fascinated me most. Didn't matter that the HOA overstepped. Didn't matter they tried leveraging fake authority against private land. To certain people, anybody who pushes back against institutions automatically becomes the troublemaker. I had one guy at a gas station tell me I should have worked with the community instead of embarrassing everybody. I asked him if he'd feel the same way if somebody tried taking his backyard because they preferred a better view of the lake. He didn't answer, just paid for his coffee and left. A couple months later, I was back out repairing fence posts near the eastern bank, exactly where this whole mess started. Same lake water, same wind through the reeds, same mallards drifting around like they owned the place. And honestly, maybe they did more than any of us. Elaine stopped by that afternoon carrying another jar of peach preserves and asked if I thought the whole ordeal changed anything permanently. I remember leaning against the fence line thinking about that for a minute. Not really, I told her. People still want what isn't theirs. Other people still think paperwork doesn't matter until it suddenly does. She laughed at that. That sounds cynical. No, I said. Just old-fashioned. Because the truth is this story was never really about an HOA. It was about what happens when confidence outruns legitimacy, about people mistaking appearance for authority. My grandfather understood that long before I did. That's why he kept records, why he wrote careful clauses, why he taught me land doesn't disappear all at once. It disappears one signature at a time when nobody's paying attention. And maybe that's the part one keeps thinking about most. Not the courtroom, not the settlement money, not even Vivian Caro walking out of that hearing looking like somebody had kicked a hole through the floor beneath her life. It's the fact this entire thing only existed because a few people convinced themselves ownership was whatever they could get away with. So now I'm curious what you think. If you were living inside that community, would you have sided with the HOA trying to protect property values, or with the landowner defending what legally belonged to him? And at what point does community power stop being protection and start becoming entitlement? Let me know down in the comments, because I promise you, this kind of thing happens a lot more often than people realize.